Hey there, in this video I'm going to be talking about what happens when you use the public defender for a domestic violence case. My name is Veronica and I'm a criminal defense attorney here in California. I help people put their cases behind them so that they can enjoy their lives and their freedom. And I am a private attorney, but I'm going to be talking about three big things that happen if you decide to use the public defender for your case. And when I say decide, you may not have much of a choice, right? And if you just got arrested and you bonded out, and let's say it's a felony case that's $50,000 bond, you probably paid $4,000 to $5,000, maybe you're making payments on that, the financial burden on you is already pretty strong. So you may be thinking, look, maybe the victim doesn't want to press charges, there weren't really any injuries. Is this the kind of case where I really do need to hire a private attorney? Maybe I should just see what happens if I hire the public defender. And so let's go through three big things that are going to happen if you hire the public defender. Make sure you stay tuned for number one, because number one is about some shocking admissions that public defenders themselves here in Los Angeles County have made about the quality of their representation. Okay, so let's start with number three. If you got arrested and you have not been to court yet, you got a court date maybe a few weeks, maybe a few months out, what you may not realize is that right now is actually the most important time to hire an attorney because charges have not been filed against you yet. The district attorney still needs to look at the police report and anything else in the file about this case and decide whether or not they should file, more serious charges, less serious charges, go along with whatever you were arrested for, or most importantly, drop the case altogether. And so my job as a private attorney, when someone hires me before their first court date, is to contact the DA and make sure that they know all of the good things about my client. So sometimes we submit letters of recommendation, character letters about the client, work, education, dreams for the future, their family life, if they have hardships, whatever those hardships were. If there's enough time before court, sometimes I'll send my client to classes or therapy, and we'll submit proof of that, which can be very persuasive to the district attorney who's looking at this and deciding what to do with the case. Sometimes the alleged victim wants to make a statement. Actually many times they never wanted you arrested in the first place, or maybe they were mad, they were drunk, all kinds of reasons why they may have said that you did something you actually didn't do. So they may want to now correct that. And unless you have an attorney who's submitting all of this to the district attorney is only going to look at whatever's in the police report when deciding whether or not to file the case. So they won't hear your side of it. They won't hear that the victim wants to drop charges. They won't know about your work history or hardships or any of that unless you hire someone to tell them. And the problem with waiting for the public defender or waiting to see, maybe if I do nothing, they'll drop the charges. That's true. They might, but once they file, it's going to be a lot more difficult to get the case dismissed. So if you wait until that first court date and they do file charges against you, now you missed your chance. And now the DA who is assigned to your case is not going to be this DA whose job it is to look at the files for, a minute or two and put them in one of the buckets. Don't file as misdemeanor, file as felony. That's not going to be the DA who's assigned to your case. The DA assigned to your case is assigned to get you, to prosecute you, not to decide whether to prosecute you. That decision will have already been made at that point, so you lose your chance. You've missed this really big, important opportunity to get the whole thing dropped without ever going to court. So that's downside number one. The second thing that's going to happen if you use the public defender is once charges have been filed, the public defender is going to try to get your case over with as quickly as possible. So that means that when you get an offer on the first court date and the public defender hasn't looked at the police report, hasn't really talked to you, doesn't know anything about you, they're going to try to get you to take that offer, and it's not going to be a good one. This is, the closest analogy I can come up with is like paying sticker price on a car. It takes time, right, to sit there at the dealership. I know I've been there until late at night trying to negotiate, trying to get the best possible price. If I only had, 5 minutes to negotiate with the salesman, then I'm going to end up paying sticker price or very close to it. And don't just take my word for it. There's actually a Los Angeles Times article that came out where public defenders are talking about how they are so overloaded that they cannot provide effective representation. And I want to highlight some of the things that they said because I think it's really shocking, and it makes it clear that you can have an attorney who is a really great attorney who genuinely wants to help you, assigned you as your public defender, but that doesn't mean that they are able to help you. So in this Los Angeles Times article, a reporter interviewed public defenders in Los Angeles County about the fact that their caseloads have gone from around 100 per attorney to about 300 per attorney. Even 100 is a lot, but now they're at 300. And they got some quotes from public defenders. Here are some quotations from the article. Several attorneys said that they are struggling to meet the demands of their weekly court schedule and fear they are performing the bare minimum for their clients. To get better offers in these domestic violence cases, many times we are going to have to file pretrial motions. We're going to have to submit a packet of all the good things about you. There's a lot of work that needs to be done outside of court. But alarmingly, according to this Los Angeles Times article, the caseload crush has left them unable to spend time petitioning for pretrial diversion, that's like classes in exchange for a dismissal, or alternative sentencing on behalf of clients who might qualify for such services. That type of work is simply too time-consuming with current caseloads, one public defender said. Now, that should be very concerning to you unless you are cool with having a criminal record. If you were charged with Penal Code 273.5a, that's felony domestic violence in California, unless you're okay with having a felony on your record, you can't have an attorney doing the bare minimum for you. And even if you were charged with a misdemeanor, are you really okay with being on probation, with having a criminal record? And what a shame if you would have qualified for just taking, domestic violence classes and then they drop the whole thing and it's as though it never happened. But because you used the public defender and because the public defender said, since they don't have time, hey, take this deal, this is the best you're going to get. I mean, at that point, you may feel like you really have no choice but to trust them and take their advice and take the offer. Or maybe you're thinking, man, I should have hired a private attorney, let me hire one now. And if you do that, that probably is the best choice if you've made it that far. But the problem is that you've already missed your chance to get it dropped before court with that attorney. Consequence number one of using the public defender is that if you go to trial, and I'm talking about a 5 to 10 day jury trial like you see on TV with those attorneys who make speeches, who fight for their clients, the public defender assigned to you for your trial is probably going to spend less time preparing for your trial than I spend preparing this video. When I was in law school, I interned at a public defender's office, and some of the public defenders did have time in the afternoons to work on the cases for trial. Although I, at that time, was in suburban county, they were not overburdened like many of the public defender's offices in California. And the Los Angeles Times article has even more quotations from public defenders about this exact issue. One attorney says, honestly, I don't think I'm effective right now. Most people are surviving week to week. Unless the case is set that week, you're not thinking about it. Another said, when cases get unreasonably high, what happens is the representation becomes very focused on what is happening today in this courtroom. It's not high quality representation to deal with everything the day of the proceeding. We need to investigate. You need to research, write, and file motions. You need to be able to talk to your client in a confidential, non-reactive environment. So essentially, they're winging it. The last thing that you want at a jury trial is to have your attorney winging it. And these three consequences work together to give you a worse outcome than you probably could have gotten if you hired a private attorney. First of all, charges have been filed against you and you miss your opportunity to get your charges dropped before court. Now you're assigned an attorney who's just trying to get rid of your case as quickly as possible because they have too many cases. And you know that you probably are going to have to take that deal because if you go to trial represented by an attorney who is winging it, then you're probably going to lose. And if you lose, you're going to get an even worse sentence than the bad deal that the attorney is trying to get you to take. I hope that you found this video helpful. If you did, please don't forget to subscribe, like, and ring the bell. And if you do have a criminal case in California, feel free to book a consultation with me. You can find the link down below. You can also find my number there.